bit of his background with everyone. Scott is the co-founder of the law firm Rifkin Weiner Livingston LLC, serves as chair of the firm's state contracting, procurement, and bid protest practice areas. He has represented contractors in more than 50 appeals to the Maryland State Board of Contract Appeals. He previously served as Assistant Attorney General for MDOT, where he helped to draft the procurement laws. And Mr. Livingston has been a member of MTBMA for a very long time, previously with Maryland Highway Contractors for 30 plus years. So without further ado, I'm going to hand this over to Scott.
Well, good morning, everybody. My name is Scott Livingston. I'm happy to be here. Thank you, Laurie, for the introduction, and thank you for the opportunity to meet with and talk to most of my friends who are members of, used to be MHCA and now MTBMA. This morning, I'm going to talk about COVID-19 and protecting your margins. I didn't name it protecting your profit margins because I thought some people might think that's a bit taking advantage of a bad situation. But really what's happening is I want to take advantage of my background to help you protect your profit margins. By that, I mean that when you submitted your bid, you didn't put any money in your bid price to cover the cost of a COVID-19 shutdown. You didn't put into your bid price anything at all for this huge health crisis. What happens if you incur extra costs resulting from the health crisis? Well, under that circumstance, it's only fair that you get compensated. And so what I want to do today is figure out ideas that we can share about how to deal with COVID, how to deal with the disruptions, the delays, the changes, and in particular, how you keep track of those so that if there's ever an opportunity for you to be compensated, you'll have adequate records to make sure that you're entitled to, or able to prove what you really lost. So with that, I put on the, thank you, Laurie, for putting on the slide. It says, prepare plans to do work as changed and keep good records. I want to go through each of those words. Prepare to do work. The only work you're supposed to have done when you put in your bid was the work that was set forth in the invitation for bids or the RFP. You don't have any money in your bid price for things other than doing that work. And here's what I mean by work. The plans and specs spell out fairly exactly what you're supposed to do, but it also includes a general provision called the changes clause. In Maryland, beginning about 40 years ago, when the then new procurement laws became applicable to the Maryland Department of Transportation, there was a recognition that there ought to be a fair allocation of risks. Well, one risk that you have is the risk that it'll cost you more than you estimated to do the work as originally required. Well, there's another risk, and there's a risk that for whatever reason, the government's going to want to change the contract. And most of those times are red line changes initiated by SHA or MDTA, and you comply with them, and you adjust your price accordingly. Turning to the COVID situation, what happens if the contract requirements are changed due to COVID? Or more precisely, what happens when the government procurement officer directs you to make a change? Let's use this example. You're out on the job. It's April 15th. The weather has now finally has changed. Paving can start usually. And the government procurement officer observes that one of the employees in the crew over there with the operator, that the operator was sneezing. And he looks like he has symptoms based on what a non-doctor observes out in the field. And then all of the crew, then his particular crew with 5 or 6 folks, were in the same place together back in the field office a minute ago. And he decides, the procurement officer, that he better shut down the job. He shuts down the job. Well, what happens now? You start incurring costs and there's no corresponding revenue. So what I want to do is get you to recognize that that's a change in the contract requirements ordered by the contracting or the procurement officer or the resident engineer, and you have to abide by it. So you do. You demobilize, well, that costs a quick, I don't know, $10,000, $25,000. You send home the labor, you somehow make sure the equipment is secure, you make sure the materials are staged where you want them to be and not susceptible perhaps to get stolen, and you have to notify your subcontractors. Well, okay, you do that, and you know you're going to have to remobilize. You hope to in the several weeks following or the several months following. You don't know, but you're still incurring costs. Well, that's a problem because there's none of that cost reflected in your bid price. So what do? Keep track of your costs. And what I want to do now is talk about two things: quantifying your cost increases and quantifying your delays. So can you, Laurie, switch to the next slide? I'm waiting for, there we go. To begin with, you must have, I'm assuming, I've seen the list of those who are here. The likes of Reliable, Skanska, Concrete General, you have really good accounting systems. I imagine they're susceptible to considerable flexibility. What I want you to do is set up an accounting code to capture all the costs associated with the COVID crisis. And you may want to do it in 2 or 3 different ways. There ought to be a cost code for the increased costs incurred by the contractor in each of the different projects. Another code, perhaps, that captures the cost associated with extra work done by the home office. I mean, remember, the folks hired in the home office, they were busy enough a month ago or 2 months ago. Now they have to do all this COVID stuff that they didn't know much about and that they're learning really fast. So I want you to recognize that you have to really keep track of those costs at the time that you, at best you can, incur them. So let's talk about the different costs. And I want you to look at these phases that were offered to me by the very wise, very professional gentleman named Tim Mitchell. He is a construction claims consultant of the first order. He's out of Pennsylvania, does a lot of work in Maryland. So thank you. If you're on the phone, Mr. Mitchell, I can't tell if you're here. Anyway, the 4 phases. You have to identify the direct costs affected by the suspension and disruption, mainly by comparing what you originally planned your costs would be versus what you're actually incurring. That's a good first step. Keep in mind on this phase 1 that you very likely did some of these same types of work a year before, and you may actually, you know, when the project on these big horizontal jobs, you already had to incur some of those costs. I don't really know this, but perhaps you keep track of how much it costs to mobilize to begin with respect, for example, to situating a big crane someplace or other equipment to get the work done. So you can compare the actual costs to that which was reflected in your estimate, and you can compare your costs to analogous work performed elsewhere on the project or elsewhere on another project. The next thing is you want to identify the variants that will affect direct costs, such as wage rates, material and equipment costs. Let me start with wage rates. Thanks to a new recent law, you have to pay more for sick leave. You have to pay for sick leave in a circumstance where you might not have done otherwise. The various state laws and to some extent federal laws that will make you do that mean that your costs are going to go up. Well, you ought to be able to keep track of that, and please do. It may be that you'll get compensated to some extent by one of these federal programs, and maybe not, but you want to keep track of what your actual costs are for labor. And one way to do that is to set up separate cost codes. With respect to equipment rates, some folks have internal equipment cost systems where one project costs are developed on average through the use of, you know, your CPA formulas and all. Another way is to just look at the actual, you know, invoice you're paying, which is the better way. So the equipment rates are going to change in a few ways. First, whoever leased you the equipment is going to insist on getting paid extended equipment rates, lease rates, unless you have some magical deal with that person, that entity. If it's a related company, you will have such a magical deal, and if it's not, you know, if it's not an affiliated company of yours, you're going to have to pay those costs. Keep track of them. There's another thing about material and equipment rates, material costs. the equipment may need spare parts. The spare parts may or may not be so available. So the equipment may or may not have to remain idle. Keep track of all that. I want to turn to phase 3 in your plan. When I say your plan, I don't know how much of a plan you currently have, but you ought to develop a plan. The plan ought to be in writing. The plan ought to be managed for the result that you want, namely to be made whole after COVID comes and goes and you're stuck with all these high costs. And for that, I'm going to recommend in a moment, you ought to assign it to a single person, and I'll explain that momentarily. Equipment and labor availability. Well, if the job is shut down, your laborer is going to try to find a job elsewhere. Well, I don't know if you'll ever get them back. You may or may not. And if you do get them back, they may or may not come back at the exact moment when you need them, when the remobilization is ordered or the job is no longer shut down. Plan for that. Plan for keeping track of how to find these folks. Plan for the potential increase in price you have to pay if there's a labor shortage that, like we've had over the last couple of years. In the event that there's a new infrastructure program to give more money to people to build things, as we sometimes hear rumors about here in the DC area, well, then the labor shortage is going to be even more difficult to deal with. With respect to equipment, apart from, well, you have spare parts that are going to be a problem to get. The equipment may suddenly be more lucrative if assigned to a different project. Well, if you're going to assign it to a different project where it's more lucrative, and it's not an SHA job, then you're going to have to do what Lucille Ball used to say to Ricky Ricardo. There's going to be some splaining you'll have to do. Keep track of how much those costs are, and work with SHA or the owner to make sure that you're doing things that SHA will appreciate, not oppose later on if it learns these details later. That's what those weekly or bi-weekly perhaps progress meetings are all about, even though they'll be done on Zoom like this one is here. The next of phase 4 of how to prepare and identify and capture the costs is to understand that the originally planned productivities will likely be impacted, and the contractor is better off demonstrating in real time instead of at the end of the project those costs. So if the crew you planned on having do the work is no longer available because 1 or 2 of the normal folks are gone, the foreman's gone, then you have to figure out how you'll deal with it. And the productivities that were reflected in your bid price are not likely to be achieved in the field this time. Make sure you figure out who is responsible for that. And I'm speculating it's going to be the COVID virus, which in turn is going to be causing problems for SHA, which in turn, in this hypothetical, is going to be shutting down the job. So there's no chance you're going to achieve the productivities that you anticipated. Keep track of that. So I've talked about the SHA like it's the owner, and I think there's a little tag that says owner on my face here in this photo. I think that's because my wife put that down, and I'm on her machine, her device, and she wanted to make sure I didn't forget who owns this nice Mac. Back to you. The contractors have to recognize that owners will make them whole as contractually allowed, but don't take advantage of owners unless you decide you don't want to work for SHA in the future. So be reasonable. Be reasonable. And you all know how to do that, or else you wouldn't be a success. You've seen over the years contractors come and go trying to exploit something that the government did wrong, and don't you be that. Excuse me. Also, this is an advertisement for RWL, I think. There you go. Let's get back to this. Can you change the, there it is. No, you went too far. I want to go back to quantify delays. There you go. At the progress meetings, you'll be talking about the schedule. The schedule will be completely upside down, dreadfully. Find out from SHA if there's any choice for SHA. Would it prefer to have one project versus another move steadily along, shutting down one and shifting all your forces elsewhere? Work with SHA, not against it. With respect to the CPM updates or whatever schedules you have to furnish, make sure that you identify delays caused by COVID in your narrative and on your chart. And it may be that SHA will not want you to show delays caused by COVID that are critical delays and not have them identified on the CPM. Well, I guess that's reasonable. But a thing you want to do is make sure that if you're called upon to omit from your CPM any COVID delays, so named, that you tell SHA in some other means, by a letter, you're going to nonetheless want to preserve your right to compensation for that. Here's a way to do it, which I've never seen work, but I've often heard told. Submit your schedule and submit it and give it a name, contractor's reasonable CPM, and the SHA or the owner is going to say, don't give us one that says that, just say, CPM schedule. And then you'll try, well, we're going to call it the SHA ordered or owner demanded schedule, and you'll show your schedule also without any CPM updates showing COVID because the owner doesn't want you to. And then there'll be the third one where you end up giving a schedule that looks just like all your previous ones, bland, and not identifying anything about COVID. Make sure that you preserve your rights to complain about that, or more accurately, to seek compensation for the COVID delays. Next is measuring delays. The usual way one measures a delay, a construction contractor, is through the measured mile approach. That is, you take some section of the work that's unaffected by the COVID-19 shutdowns or by the COVID-19 disruptions and show what your productivity is on that one, and then compare it with the actual productivity you're going to have on the project where COVID-19 and SHA's instructions about it are a problem. On to the next chart, please. Your back office support for claims. Each of the projects should be kept up to date with all their problems, with all their productivity, with all their costs. And that information should immediately be conveyed to the home office, which I imagine I'm confident you all are already doing. And make sure that you have separate cost codes for labor and equipment records. Materials may or may not be a big issue. There may be some materials that come from China, for example. Perhaps your subcontractor is going to be installing the traffic control devices, and some part of those devices comes from overseas. Well, the supply chains very well may be disrupted. So if you're going to be installing equipment like that, and it's going to take a lot longer thanks to COVID, that's not your fault. So we go back to the beginning, which is you submitted a bid. The bid reflected your interest in performing the work. The work did not include supply chain disruptions from China due to COVID. So what do? You should be able to put you, the contractor, in the same position you would have been in, but for those changes. Well, the government has a unilateral power to order you to change things, and you only have and you have the obligation to do the work as ordered. You only have one right, and that is to file a claim, a request for compensation. And the request, when it's called a claim, sounds rather adversarial, but the original concept, which I had a hand in drafting as an assistant AG a long time ago, the idea was that the government doesn't want contractors to inflate their bid prices just in case some bad thing might happen. Well, because what if the bad thing doesn't happen? Then it's a windfall to the contractor, and it's harmful to the taxpayer. Well, what if the bad thing does happen? Well, nobody really knows in advance if there's going to be a hurricane that's going to cost an extra X dollars versus 3X dollars. So don't put any money in for that. And when you get ready to bid projects this summer, you need to know really strong rules. And you've got Mike Sakata, who will make sure on behalf of MTBMA that estimators are informed. Look, please put into your bid an extra $1 million to cover extra costs associated with COVID. And in the event that allowance item turns out to be high priced, you won't get paid it. But somehow find a way so that no one is surprised about these claims. But again, the rationale for claims is that the government wants to encourage vigorous price competition for these projects, for these contracts. Four elements, material elements of a construction contract are price, quantity of work, quality of work, what you're actually doing out there, and then the time for delivery of the work. Well, 3 out of 4 of those are supposedly exactly specified. That is, the quantity, quality, and time of work. The only one that's variable is price. That's why the contracts are awarded to the responsible bidder who submits the low responsive price. Well, if that's the low responsive price and it has no extra money in it for potential COVID situations, there needs to be a process by which you can claim entitlement to compensation. And that's filing a claim. And the filing of a claim isn't that tricky, but you ought to file it in writing to the government so it's on notice that that's what you're doing. That's especially true in this situation because you might be willing to absorb the extra costs of back office folks who are going to spend half their time now doing COVID stuff. But not if it's many people, not if it goes on for a long time. And the fact is your bid price didn't include any money for that. So your back office support should be adjusted to make sure you can deal with the claims. And can you go to the next attachment there? Manage results. Well, in case you hadn't already figured this part out, there is going to be a lot of time spent by management on COVID-19. In your capacity as the owner of the company, you better manage that person. And as in your role as an executive, you get things done, you get work done, you accomplish the mission mostly by getting work done through others. So I recommend that you assign some executive, a single executive, to manage the COVID-19 problems. And that executive in turn is going to have his or her hands full. Mostly, among other things, because the events in the field are going to change every 5 minutes. Next, events on the part of the government, the federal government and the state government, telling you what to do, telling you to do things you never did before, and waiting till just 5 minutes after the last minute to tell you. That's going to require a lot of coordination with the field offices. And just with respect to COVID, you're better off having a single person who's in charge of all that. Or like some of my clients like to say when they hire me, look, Scott, we're hiring just you. We want one throat to choke. It's a reassuring point. The next thing is, I'd like to, I'm not sure of the time here. So Laura, you should tell me, are we near the 20-minute range? Or Mike Sakana?
Yep, you're right around it.
Good. So I think we're getting ready for questions. I want to talk to you about the questions. What I'd really like is for the construction contractors in the audience and the engineers who design these projects to please jot down one or two examples that you've already encountered in the field thanks to COVID, so that you can share with your colleagues, gee, here's a problem, we've dealt with it. What MTBMA likes to do is find out about problems before they occur. And if you've already suffered the indignity of having a project shut down and you didn't know what to do in the way of, well, how long will it be shut down for? How much security do we have to have here keeping track of it? Who's going to pay the cost of my field office out there working, but no revenue from the laborers? I'm looking for examples like that, so that we can use the remainder of this seminar, or webinar rather, to actually learn from each other. I'm enamored with the remark that you should learn from the mistakes of others, because you won't live long enough to make all the mistakes yourself. So let's see if I can get some of the questions that you may have about what we've just discussed, or I've discussed. And secondly, in particular, if you could identify a couple of one or two examples of something you've already encountered, that would be helpful. So, Laurie, by now, I think others may have already written questions, and perhaps there'll be some new ones concerning examples. So I'm ready to hear the questions, and I don't know how to find them on my device here.
Sure. So we do have another colleague of Scott's on this webinar today. His goes by the name of Mike Miller. I think what we're going to do today is I'm going to hand this over to Mr. Miller to kind of go through this Q&A portion. And it does look like we do have a question that did come through on the panel.
Lori, I appreciate it. It says I'm muted, but I think everyone can hear me anyway. Scott, one of the questions that came through is that there's a concern that employees are not reporting to job sites due to fears of the virus. Do you have any advice for contractors whose employees are reluctant to show up at the job site?
Yes. in a significant sense, the reason why they're reluctant to show up is because SHA or the MDTA is owner of the project and is sensitive to the health concerns of everybody. No one knows whether those laborers, if they showed up, were carriers of the virus or not. But the laborers know that if they show up and they are carriers, they're going to be labeled that, I suppose. So just have them send in an email that says, hi, this is so-and-so. I'm not coming in today not because I'm not healthy, but out of concern that SHA may take action that would be adverse to me. Namely, because a week or so ago, SHA has a rule that now requires anyone who has any situation has to be tested, and there are no tests. So the guy would be coming to work and not being able to work anyway, not earn any money for himself and not earn any money for the company. But it's all because of COVID, and it's in particular because of SHA or the government officials concerned for health, thanks to COVID, issuing orders and rules that now make it better for the contractors' employees to stay home. I do not know about the obligation to pay hourly rate workers during that time, other than the fact that there's some new federal rules on the Families First and the payroll protection program that deal with this. That's all and this is a good example, since Mike Cicada is on the line. This is a good example. Every one of the contractors that are members of MTBA is an employer, and in their respective capacities as employers, they need to get advice about how to proceed on this. This is a good one to work with SHA on. Sorry, I couldn't be more definite on that.
That's okay, Scott. Actually, I would just kind of jump in and explain that at RWL we've created our firm has a committee of attorneys that are focusing on issues, including employment law issues related to COVID-19. And while Scott and I may not do much in the way of employment law ourselves, we do have individuals, professionals that deal with employment law concerns, and they are focusing on the Families First and the various coronavirus related legislation that has come out in the last few weeks. So I'm sure they can provide particular advice on your specific situation. If you want to contact us offline, I think that would be the most helpful way of looking at how many specific employees you're having problems with, what your responsibilities are to them, and what your remedies could be.
You go ahead. I'm going to thank the person who sent in that question. That was a good question.
So let's go to another one here. There's a question as to whether it would be a better idea, instead of providing notice under a contract's force majeure provisions, wouldn't cost entitlement be easier to claim using suspension provisions of the contract? And I want to warn everyone listening in. A lot of the time, I've looked at a few contracts in recent days for this, and some state contracts do not mention a force majeure provision. They do allow for suspension, obviously, but I think it's a little difficult without looking at each specific contract and the terms that are incorporated therein to know which is better. But Scott, do you have any comments on that about force majeure versus cost entitlement?
Well, what I really think we should do is we should work with Mike Cicada, take a look at the standard SHA specs, which govern SHA, MDTA, MTA, et cetera, and give him a memo that explains what the rules are and how to protect your margins. And in general, if there is a suspension ordered by the government, a shutdown, then there are, generally speaking, rules which generally say that the contractor's obligation to complete the project on time is excused thanks to the suspension, and the contractor is entitled to his actual, reasonable, allocable, and non-disallowed costs that are incurred during the suspension, but not profit. SHA and contractors are not structured like federal contractors are on cost-plus contracts. So it's going to be a little bit it's going to be a lot of an adjustment to keep track of all that. But let's first find out what are the specs that govern. And so when I'll look back at if Mike Cicada wants us to, we'll help you, give you some advice about how to deal with that on SHA projects. But when it comes to doing public school construction or projects for Baltimore City or Baltimore County, I don't know the answer because I haven't seen those contracts. And with respect to JMT and all the terrific engineers that I've represented over the years who actually, draft these plans and specs, and they put in there the specs that are required, I don't know what the suspension clauses, if any, are in, for example, a Baltimore County project. So we need to see all those.
Yeah, I want to agree with you, Scott. We don't know exactly which provisions are at issue in each contract. I would warn everyone listening, though, that under the SHA standard specs, if you look at GP 7.16, contractor's responsibility for work, subsection B talks about suspension of work. And it says that right at the beginning that in case of suspension of work for any cause whatsoever, the contractor shall be responsible for the project and shall take such precautions as may be necessary to prevent damage to the work, provide for normal drainage, and shall erect any necessary temporary structures, signs, or other facilities at his expense. It seems that provision seems to be aimed mostly toward landscaping, erosion and sediment control sort of issues. But I think contractors need to be careful that if they're going to leave the job site because they don't have employees showing up and they're not doing work actively during the suspension of work, they have to make sure that they don't leave the job site in such a condition that all of a sudden there could be damage to the job site that they'll need to go back and fix later on. They have to be really, really careful about that because I can see under this clause that SHA may hold them liable for it. So you need to be careful.
Before we leave this, I observed that Jason Couch, the really professional Assistant Attorney General at SHA, registered. I don't know if he's here or not. If he's here, then I don't want him to hear how nice I think he is. He's really smart and very reasonable, and he's the exact right person to sit with and to figure out how to allocate those risks and get in the room the folks who are actually building things like Steve Busey and our contractors and figure out what is a reasonable way to deal with these. Otherwise, you have this fearful prospect that, I don't know, 100 different contractors are going to have 100 different issues on 100 different projects, and then one of them is going to get the honor of having to go to the Board of Contract Appeals to find out what's what. Meanwhile, a year or two will pass by, and that's not a good way to do business. We can anticipate these problems. Let's deal with them in advance as best we can and codify, or at least write down, the general principles that are going to guide disposition of these claims and compensation for the contractors. Any other questions, Mike?
No, I just want to chime in on one, how I've always been I've been jealous of Mr. Couch's facial hair. Number two, I think your comments on SHA, Jason Couch, and the folks over there being reasonable and being willing to work with contractors is spot on. I think they've shown that they're very good at working with contractors in a reasonable manner, and I think that going forward, determining what is excusable delay based on COVID-19 is probably going to be an ongoing issue for some time, and that it's worth talking to them if there are significant delays to your project or if there are suspensions, talking to them about what they would be willing to work out as far as compensation, excusable delay, things of that nature.
So, Laurie, I think or Mike, are you on the phone, Mike?
Yes, sir. I want to, first off, thank you both for this wonderful presentation. And I know obviously we are in conversation with SHA, and they obviously also are trying to figure this thing out as well. So, but understand that this is ongoing, changing, and kind of fluid. So we appreciate getting us prepared for kind of next steps here. I really appreciate it, Scott.
Well, you're welcome, and everybody, good luck. Stay home, stay safe, and protect your profit margins.
And I would simply say that if you have any additional questions that we didn't answer today, be sure to contact us offline. MTBMA has our contact information. I'm sure they'll be sending it around. There it is on the screen. Be sure to send us an email, call us, let us know if you have any additional concerns related to any specific project, and we will be sure to respond to you in